Good morning. Can we get a roll call?
Present. Here.
Here. Here.
Here.
Thank you very much. I'm going to read a statement into the record by Commissioner Lyle. He asks this to be placed on the record, the fact that he could not attend today's meeting in person due to a previously scheduled trial. He would be in attendance this morning if he could participate remotely. The request was denied, given the fact that the commission has not taken a position on remote attendance as of yet. We're waiting for him to come back so that we can have a full discussion with the full commission. Thank you. And the Pledge of Allegiance, please stand. I pledge allegiance to the flag
Of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. I have some housekeeping announcements. The First District Court of Appeals graciously let us use their facilities, so please respect their rules and have absolutely no food or beverages other than water in this room. And please silence your cell phones. That's a good idea. We have received some feedback from the public that sometimes it is difficult to hear the members and those before the commission, both in the room and over live stream. Anyone addressing the commission, please make sure to speak up and speak into the long microphone at the platform so that you can be heard, and so our broadcast audio and recording equipment can pick up your comments. To my fellow commission members, please speak up into the long microphones on the dais so that your comments and debate can be heard. If you share a microphone with another member, please pull it close as possible to you when you are speaking. Members, I ask you to be as brief and concise as possible in your questions and comments, as we have a number of items for consideration today. Maybe not so. Pursuant to Section 286.0114 Florida statutes, members of the public have the opportunity to have input on matters before the commission, other than in cases in which we act in a quasi-judicial capacity. This means the public can have impact on matters other than complaints, opinions, and determinations in financial disclosure cases. If you desire to be heard on the matter, please fill out a speaker card and give it to Ms. Fulford, who has her hand up in the back. Thank you. The approval of the minutes from the public session, April 25th, 2025. Can I get a motion?
So moved.
Second?
Second.
All in favor?
Aye.
No opposition? Motion passes. Item 4. Let me get through it. The next two items for our consideration today relate to complaints where probable cause was found in a previous meeting of the commission. We have now before us a proposed joint stipulation, between the commission advocate and the respondent. After considering all the materials and presentations of the parties, the commission may vote to approve or reject the stipulation. If the stipulation is rejected, the parties cannot negotiate and present a new stipulation at this meeting. The complaint would go to the Division of Administrative Hearings for an evidentiary hearing, or the parties could negotiate a new settlement for consideration at another commission meeting. We will now consider the stipulation complaint number 24-268, Ain Ray Annette Redmond. Would the parties in attendance for the matter please identify themselves for the record? Nobody here? Are there any members of the commission that need to make a disclosure regarding this case? If so, please state it for the record. No comment. Ms. Hadley, you've recognized.
Thank you.
Proceed.
Respondent serves as a member of the Lake Butler City Commission. The commission found probable cause to believe she violated Section 112.31433 and 112.3136. The parties entered into a stipulation regarding both matters. In the stipulation, respondent admits that she violated the aforementioned sections and agrees to the entry of a final order recommending a civil penalty of $4,000 with public censure and reprimand. We respectfully ask for the Commission's approval of the joint stipulation.
Any questions for the members? And respondent's not here. And get a motion to approve the recommendation, the stipulation?
Move to approve.
Second?
Second.
All in favor?
Aye.
Any opposition? Motion passes. Thank you very much. Item 4B, the next stipulation up for consideration is complaint number, it's two of them, numbers 24-277 and 24-280. Tamara Goller. The complaint did not want to file a written response to this stipulation. Will the parties or counsel identify themselves for the record? Are there any members of the commission who need to make a disclosure regarding this case? Seeing none. Mr. Burns, you are recognized to present the stipulation. Good morning.
Thank you, Chair. At the Commission's last meeting, the Commission voted and found probable cause that the respondent, who is a City Councilwoman from Marco Island, Florida, violated Section 112.3136 and Article 2, Section 8H2 of the Florida Constitution. In the proposed joint stipulation before you, the respondent agrees that her conduct violated both provisions and agrees to recommend a public censure and reprimand and a $2,500 penalty for each allegation for a total of $5,000. We ask the Commission to please approve the joint stipulation.
Thank you very much. Any questions from the members? Can I get a motion to adopt the stipulation?
Move to approve.
Second?
Second.
Thank you. All in favor, say aye.
Aye.
Any opposition? Stipulation is approved. Thank you. Okay. Item 5. What we have before us is going to be file number 2819. The next agenda item in this consideration of advisory opinion, file 2819. Any public officer, candidate for public office, or public employee in Florida who is in doubt about the applicability of the disclosure laws or standards of conduct to himself or herself or anyone who has the power to hire or terminate another public employee may seek an advisory opinion from the Commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Is the requester in attendance?
Yes.
Thank you. Please identify yourself.
Tim Martin.
Thank you. Amelia Naomi, good morning. You can present the draft opinion. Thank you.
Thank you, Mr. Chair. So this opinion concerns the applicability of the in-office lobbying ban to an elected mayor who, in his private capacity, wishes to advocate for certain policies before the federal government on behalf of his employer. So first, to provide some background, Mr. Tim Martin was recently elected to be the mayor of Newberry, Florida. In his private capacity, he is employed by an entity known as the John Birch Society, where he's paid to serve as the organization's National Development Officer. In this role, Mr. Martin has stated that his primary job duties involve fundraising for his employer. This is done through soliciting donations, business advertisements, and making arrangements with those who want to include the John Birch Society in their estate plans. He has stated that he also works on special projects and advancing the overall mission of the John Birch Society as well. So separate from these job duties, Mr. Martin has indicated that he plans to go to Washington, D.C. once every other month to advocate for certain policies on behalf of the John Birch Society. Regarding the scope of his duties as they pertain to these trips, Mr. Martin has stated that he will be advocating for elected officials to adhere to the Constitution on various legislative matters, which includes advocating for anti-war and anti-central banking policies, as well as advocating for the withdrawal of the United States from the United Nations. Outside of these trips to Washington, D.C., Mr. Martin has stated he may periodically send written correspondence or documentation to follow up on a visit. So against this backdrop, Mr. Martin has asked whether the work he will be doing in his private capacity would violate the in-office lobbying ban found in Article 2, Section 8F2, Florida Constitution. Ultimately, it is our recommendation that you find it does not violate the in-office lobbying ban. So turning to the language of the ban itself, Article 2, Section 8F2, Florida Constitution states the following. A public officer shall not lobby for compensation on issues of policy, appropriations, or procurement before the federal government, the legislature, any state government body or agency, or any political subdivision of this state during his or her term of office. Since Mr. Martin is a public officer subject to the in-office lobbying ban, it must be determined whether the conduct he has described in his inquiry amounts to lobbying for compensation, as this is the conduct that the in-office lobbying ban prohibits during the course of a public officer's term of office. So the term lobby for compensation is defined in our statutes. It's in Section 112.3121, subsection 12A. And this provision states that lobby for compensation means being employed or contracting for compensation for the purpose of lobbying, and includes being principally employed for governmental affairs to lobby on behalf of a person or governmental entity. Importantly, and relevant to this inquiry, Section 112.3121, subsection 12B2, Florida statutes, explicitly states that the term lobby for compensation does not include the following: a public or private employee, including an officer of a private business, nonprofit entity, or governmental entity, acting in the normal course of his or her duties, unless he or she is principally employed for governmental affairs. So, in sum, conduct by public officers is not considered to fall under the definition of lobbying for compensation if they are acting in the normal course of their private job duties, unless they are principally employed for governmental affairs. So because the advocacy that Mr. Martin will be engaged in during his trips to Washington, D.C. will be part of the normal course of his job duties at the John Birch Society, in order to determine whether this conduct falls under the definition of lobbying for compensation, it must be determined whether Mr. Martin is principally employed for governmental affairs by his private employer. So the term principally employed for governmental affairs is defined in Section 112.3121, subsection 15, Florida statutes. This provision states that principally employed for governmental affairs means that the principal or most significant responsibility of the employee is to oversee the employer's various relationships with governmental entities or representing the employer in its contacts with governmental entities. So in this case, Mr. Martin has indicated that his primary responsibility in his private employment involves raising money for his employer through various means, again, including soliciting donations, business advertisements, and seeking the inclusion of the John Birch Society in people's estate plans. Regarding Mr. Martin's representation of his employer in its contacts with governmental entities, I'll reiterate that he has stated he will only be going on trips to Washington, D.C. once every other month, or 6 times per year. Based on these facts, therefore, it does not appear that Mr. Martin's duties in his private employment bring him into the definition of being principally employed for governmental affairs, as his primary and most significant responsibilities with his employer involve fundraising, not representing his employer in its contacts with governmental entities. So, in sum, Mr. Martin's responsibilities at the John Birch Society do not amount to lobbying for compensation, because what he will be doing is within the normal course of his job duties, and he's not principally employed for governmental affairs. Therefore, while Mr. Martin is subject to the in-office lobbying ban, the conduct he has described in his inquiry as it relates to his private employment will not violate the ban. So now I offer this draft for your consideration, and I'm happy to answer any questions.
Thank you very much.
I have a question.
Oh, go ahead, questions.
Which one?
The long one.
Thank you. My question is, in his duties as lobbying, does he use the title Mayor Martin or Mr. Martin?
I am not sure of that answer, but he is here, and I'm sure he would be able to answer that for you.
You want to, is that the question?
That's my question. I don't know who can
That's
answer.
right, you can approach it. Thank you.
Good morning, members of the committee. My name is Tim Martin. To answer your question, Commissioner, is it Stewart? No, I just simply referred to myself as Mr. Martin. So if you have any other questions?
That was it.
Okay. Thank
Ed,
you.
would you like to address the commission in any way, or besides answering questions?
Well, I'd like to certainly appreciate the work that Ms. Naomi did. I thought the summary was fairly accurate. We had a lot of back and forth, as you can see in the backup, and I think the two salient points really here are, as she mentioned, the principally employed and lobbying for compensation. I don't get paid any additional money for doing any of that. There is no exchange of money as traditionally probably associated with lobbying or anything like that, and it certainly does not rise to the principal duty that I actually do for my organization.
Thank you. Any questions from the members? Nope. Thank you very much.
Thank you.
Any discussion? Yep. Can I get a motion to adopt the draft opinion?
Move to approve?
Second?
Second.
All in favor?
Aye.
Any opposition? Legal opinion passes. Thank you very much to adopt. Thank you, Naomi. Second, the next agenda item is the consideration of advisory opinion, file 2820. Is there a requester in attendance? So you please state your name for the record? Thank you very much. Mr. Gray, I'm sorry, Gray Schaefer. It's a great name. It's just a great name. It's a great name. And of course, wearing a gray suit again. You may proceed, sir. Thank you.
Thank you, Chair. This opinion request is being brought by a current employee of the Department of Corrections who's here this morning. It concerns whether any post-public employment laws in the Code of Ethics will apply were he to leave the Department of Corrections and accept a particular position with a vendor that's providing health care services to department inmates. The employee in question serves as the assistant warden at the Everglades Correctional Institution, which is a facility located in Department Region 4. Keep that department region number in mind because I'm going to be circling back around to it several times. His job as the assistant warden predominantly concerns overseeing the security at the Everglades facility, although he's also involved in the general administration of that facility's day-to-day operations. The position being offered to him is to leave the department and accept private employment with Centurion, which is a private vendor providing health care services to inmates at all department facilities. Centurion would like him to serve as a House Services Administrator at the Dade Correctional Institution, which is a facility located in Department Region 4, just like the facility where he's currently working. From what we've been told, the House Services Administrator oversees all the medical teams working at the particular facility where they're assigned to make sure that quality care is being provided to the inmates there. It's a position that requires them to be physically present at the facility where they're assigned, which means that if the assistant warden here accepts this job offer from Centurion, he'll be physically placed at the Dade facility. And obviously the position will require him to interact with the officers and staff at that department facility. Now, the question before us is whether the assistant warden is prohibited or limited by any post-public employment law in the Code of Ethics from accepting this particular job offer. I will say I've been corresponding with this requester. I've already written him 2 letters providing informal guidance to his scenario, but he's asked that the full commission consider his request. So any formal opinion that you adopt this morning will supersede the guidance that I provided to him in prior letters. I'll also say that while preparing this draft opinion for your review, he and I went into even greater depth on his job duties as the assistant warden. And given the new information that was provided while I was preparing this formal opinion draft, I actually changed the recommendation I made in the letters on one of the statutes involved here. That statute is section 112.3185. It applies to former executive and judicial branch employees. It imposes different limitations on them leaving public employment, then accepting work on contracts that they either help procure or that they had responsibilities for while they were at their former agency. Here, there's no indication that the assistant warden was involved in procuring the Department of Corrections contract with Centurion. So that part of section 112.3185 that deals with procurement doesn't apply. The question then becomes whether he had any responsibilities concerning a Centurion contract as a department employee. Section 112.3185, subsection 4, says that for 2 years after leaving an agency, a state employee can accept employment regarding contracts that fell within their responsibilities while they were at the agency. So it's a 2-year ban on accepting work on those type of contracts that fell within your responsibilities. As you can read in the draft, After taking a very close look at this individual's duties as the assistant warden, it doesn't appear the Centurion contract falls within his responsibilities. The commission has found in the past that phrase, "within responsibility," means you have some type of monitoring or managing role regarding a contract, or that you supervise someone who does. And that doesn't seem to be the case here. He's not the monitor or manager on the department's contract with Centurion, and the employee who actually does manage it within his department region is not under his supervision. Now, as you can read in the draft, it does appear that as the assistant warden, he does come into contact with Centurion employees, but that contract appears more perfunctory. It doesn't necessarily mean the contract falls within his job duties. For instance, Centurion employees do report different security-related concerns to him because he is the assistant warden in charge of security. But in that respect, they're just relaying information to him. There's no indication that he works with Centurion on resolving the issue or that he reviews any work performed by Centurion. Now, he's also indicated to us that he does conduct security inspections of his facility, including the areas of the facility that are the medical areas, which is presumably where Centurion would operate. But he's also said that Centurion has no responsibilities under his contract with the department to maintain those areas of the facility. So, given the fact that he may inspect the medical areas of the facility, because Centurion doesn't have any contractual obligations to maintain those areas, it doesn't seem then that his inspections mean he has responsibilities concerning the contract. So in short here, it doesn't appear that Section 112.3185 is applicable because he wasn't involved in procuring the department's contract with Centurion, and he has no monitoring or managing responsibilities regarding it. So that's the first statute that's addressed in the draft. That being said, there is a second statute addressed in the draft that we think will apply if you were to accept this post-employment offer. That other statute is Section 112.313, subsection 9A4. It applies to executive and legislative branch employees serving in SMS or SES positions. It places a 2-year prohibition on them returning to represent clients or new employers for compensation before the agency where they were formerly employed. Now, here the assistant warden is serving in an SES position, so this 2-year representation ban does apply to him. The question then becomes, what is his agency? Because the 2-year representation ban just applies to the agency we were formerly employed. In the past, the commission has found the agency of a former corrections employee is the departmental region where they're employed. Now, here, as I've said, his current facility, the Everglades facility, falls in Region 4. So does the Dade facility where Centurion hopes to place him. They're both part of his agency. So what does this mean? Well, this 2-year prohibition doesn't automatically preclude or prevent him from accepting Centurion's employment offer. He can take the offer, but the law will restrict him for 2 years from making any representations to Region 4 officers or employees on Centurion's behalf. And practically, that may limit the kinds of interactions he'll be able to have if he's serving as a health services administrator at the Dade facility. Now, the term representation is defined in the Code of Ethics and the way the Commission has interpreted it to cover any effort to influence discretionary decision-making by your former agency for 2 years after you leave it. That could be orally or in writing. It even encompasses just even attending a meeting of your former agency. Even if you don't participate, as long as you're there on behalf of a new employer or a client, that's considered by law to be a prohibited representation. The draft in front of you analyzes different types of contact that the health services administrator at the Dade facility will be expected to have with Region 4 officers and staff. And as the draft explains, not all of it may be considered a prohibited representation. Not all of that contact may be on discretionary matters, but some contact might. And the potential for a conflict is just going to increase because he's going to be expected, as a health services administrator, to be physically present at the Dade facility. So that means he's going to have to be very careful. Any comment he may make to Region 4 personnel on discretionary matters, any meetings he may attend held by Region 4 on discretionary matters, as long as he's there on behalf of Centurion, that could very easily cross the line into a prohibited representation. So in conclusion here, the concerns in the draft in front of you are centered on this 2-year representation prohibition in Section 112.313, subsection 9A4. If the assistant warden accepts the position being offered, he'll be subject to this 2-year prohibition, and that may limit the types of interactions he'll be able to have with Region 4 personnel as the Health Services Administrator at the day facility. I offer this draft now for your review. I'm happy to answer your questions, and the requester, again, is here if you have questions for him as well.
Thank you very much, Mr. Schaefer. Any questions from members?
I just want to thank both the mayor and the assistant warden for submitting a request for an opinion. It's far better to avoid a problem than find yourself in one and have to dig yourself out. My concern with the opinion that you've given is, and that your recommendation is merely that it seems like there are a lot of hazards that are going to have to be navigated along the way, and I'm just hopeful that there's enough clarity that there isn't a point where he's getting tripped up along the way. So I think you've made it clear that you've got to be careful about this, that, and the other. It just seems like it's a course filled with a number of potholes.
And I will say that he can always call us if he does accept this job offer, if Centurion still feels that it's worthwhile to offer it to him. If he has a question about whether something's going to cross the line, we're always available for him to call us and we can talk through it with him.
Any other questions, Schaefer? Thank you very much. Mr. Herron, would you like to address the commission? Proceed.
Good morning, Commission. I just wanted to express my appreciation to all of you for this fair review. That's it.
My only comment is to agree with my fellow commissioner. It seems like it's very fact-specific, almost like day-to-day,
Yes, sir.
where you have to be very careful. I mean, what's the word? Boundaries need to be established based on your communication, because the fact that you're assistant warden and they know you, they recognize you, could spill over. But the fact that Mr. Schaefer says you can call back anytime just to get some guidance, it's much better to be careful than to say, I'm sorry, or I didn't realize it.
Yes,
That's
understood.
difficult. Any other comments? Sorry, go ahead, Commissioner.
Thank you, thank you. My question is, if the employer has been made aware of these stipulations?
My current employer,
No, the one that you're trying to go to.
Centurion, yes, ma'am, they have.
They have been made aware?
Yes, ma'am.
Of all the pitfalls and all that?
Yes. I've been keeping them in the loop with everything that's.
Okay, thank you.
And thank you, Mr. Schaefer, for your.
Any other questions or comments? Thank you, Mr. Herron.
Thank you.
Can I get a motion to adopt the draft opinion?
Second.
Second.
All in favor? Aye. Thank you. Motion passes. Thank you, gentlemen. Have a great day. Item 6, consideration of financial disclosure appeals. We now turn to the appeals of automatic fines for failure to timely file their annual financial disclosure form, where no hearing was requested by the appellant. Because none of the listed appellants requested to be heard, excuse me, there will be no oral presentation on the contents of the appeals unless a member requested. Are there any disclosures a member needs to put on the record? Are there any questions from the members on the appeals or appeals that a member would like staff to present the analysis?
Yes, item 2, item 6, and item 8, I'd like to have pulled so we can discuss them separately. So item 2 is Gottardi, FD 21063. Item 6 is Miller, FD 21068. And item 8 is Ruiz, FD 23002.
Okay, those are all mine. Lucky me.
Thank you very much.
So
All
let's start
right.
with number 2.
All right, well, let's start first here with Shannon Gottardi. She's the executive director for Miami-Dade County Public Schools. This is about a $500 fine, which she has timely appealed, pertains to her failure to file her 2020 Form 1. In her appeal, she claims she never received notice. That's the particular argument that she's raising as good cause to waive this $500 fine. She's indicated that all the mail was sent to the school district building, and that would mean all the notices that were sent about her filing obligation. She said that when mail is sent, it goes to a centralized location where it's sorted and then distributed to each individual officer. And she claims that she did not receive any of those mailings, that they weren't properly sent to her from the, I guess, this centralized mail sorting center. There were 3 notices that were sent prior to the grace period. They were all sent to the same address at the school district. That would be an initial notice from the supervisor of elections, a certified notice from the supervisor of elections, and a courtesy postcard from us at the commission. That certified notice was signed for by someone else, so we can't look to that and say definitively that she received it. Essentially, there's no evidence that we can point to dispute her argument of lack of notice against someone else signed for that certified, and based on that, I recommended waiving the fine due to lack of notice.
Okay, I just got a couple of questions. I didn't see disclosed in the statement when Guattardi started serving as executive director for the Miami-Dade County Public Schools.
I don't know if that's in the order, but my notes indicate she's filed a form since 2015. Although I will say, I don't know if she was always in that same position since 2015, but she's filed the form since then.
But okay, so that answers one question that's important to me, is that she had previously filed forms. And another question I had concerned the address that it was sent to. It was a valid address that the requirement notice was sent to, is that correct?
That's my understanding. It's the address for the Miami-Dade County Public School
So it was
District.
not returned for being an improper address?
We have no indication that it was returned, but we also have no indication that she necessarily received them.
Okay. Well, it was received at the place where it was to be sent to. Whether it was transmitted into her office is another question
Right.
altogether. So, okay. It seems to me that the appellant here knew or should have known of the requirement to file a financial disclosure. It seems to me that the Ethics Commission did everything it was required to do in sending out the notice to the proper address, that it was received at that proper address, and it seems to me that we couldn't do anything more than what we've already done here, and that this is the type of an appeal that I have trouble with, where you have someone holding this office who should be held to a standard of knowing what their requirements are for holding that office, especially when they have a history of having filed those financial disclosure forms. So I would recommend, for that reason, that we deny this appeal.
I just have 2 comments to make, and I completely understand Commissioner Bain's concerns. I will say that in the past, this would be an appealable order to the district court. The district court may look to us then to produce evidence that she received notice, or else it could be considered a violation of her due process rights if she wasn't properly notified. So in the past, lack of notice has been relied on then as a type of unusual circumstance that would justify waiving the fine, although I do understand what you're saying as well. She has filed in the past. The other thing I will say going forward is that now that we are in the world of electronic filing, filers will be required to submit an email address to us of where the notices will be sent, and it will no longer be a valid argument that they didn't receive notice, because it'll be their obligation to make sure that their email address with us is up to date.
Well, Mr. Schaefer, I mean, if a certified letter gets sent to someone's home, so there's no mail distribution, and the husband signs for the wife who's serving as executive director for the Miami County School Board, and the husband throws the notice away, and the wife says, well, I never got the notice. My husband signed, and he threw it away, and I never got it. It seems to me that that's a comparable argument here. Here, the distribution process may have been a little more circuitous, but it was being sent to the address that we were directed to send it to.
That is true. Usually in the past, to make sure we're on firm ground, we like to see that the filer actually signed for the certified themselves.
Maybe we're creating work for someone to appeal the denial here, but I can't. I would have to vote against approving this one.
A couple questions to follow up on that. So then, basically, our past has been, unless you can actually show proof of service, so to speak, to borrow a term from civil land, DOE is going to request that from a due process perspective, correct?
I would think if her argument, and this would be an appeal that would go straight to the first DCA or whatever district court she would choose to file it in. I would think that if her argument is that she never received notice, they may, from a due process perspective, have some questions for us about that. We just don't have any evidence to point to show that she received it.
Okay, so the fact that she knew or should have known is not, obviously, from a due process perspective, that's not relevant at all.
That would be the only argument that we could raise, which is what Commissioner Bain laid out, the fact that she's filed this in the past and therefore should have had notice. But in the past, we've kind of taken each filing year as almost the clock starting over, as a separate timeline.
But it seems that your definition of received is it has to be in hand rather than sent to the correct address. And that's a much more narrow, specific definition of received than I'm familiar with as a lawyer or under the regulations that appear to apply.
That's the approach that staff has taken in the past. I do understand your argument.
If I may. Your Gray is touching on something that I think I want to expand on a little bit there, which is, it's not even the staff's definition of received or whatever, but the commission's in the past, the commission has taken the approach that it's not just whether or not the notice was effectuated and whether or not it did go to the proper address. The commission's goal here is not to make sure that the fine sticks, so to speak, but to effectuate the filing of the document. The filing is only ever really going to happen when they have the notice in hand and that they're aware that it's time to file. People come off the list, they come on the list. Sometimes they move positions, things change. They have spending authority, they don't have spending authority. There's lots of things that can move them on and off the list. That notice goes out every year, we put it in their hand. The commission has taken the tack that, in the past anyway, that if they don't have the actual notice and if we can't demonstrate that they do, that we'd rather effectuate them getting to file. So that's where we've been with it in the past.
So it seems like the way that, what you're saying to me is unless they actually sign the certified mail card in their own signature confirming that they've received it, they can always argue that they never received it.
The standard to answer your question, the standard at the District Court of Appeal is going to be whether or not there is competent substantial evidence to substantiate what we're doing here. We have a statement from the individual saying they did not receive it, and we have nothing, right? And so, we have a certified mailing that they didn't sign for. We have no objective evidence that they did get it. So we have a statement from them versus nothing, and in the past, the board has not felt like it wanted to go forward with that.
I wouldn't say that we have nothing. I mean, we sent it to the correct address. It was received at that address. As far as the commission is concerned, we did everything that we were obligated to do, sending it to the address that we were told to send it to.
That is, you would be within the law, I think, to go that way, if that's what you're asking. We could support that. That's not what the commission has done in the past, and that's why the recommendation before you is what it is.
All right. I'm going to get a motion on, I guess, case 21063 to approve Mr. Schaefer's recommendation or disapprove?
I move to deny.
Okay, move to deny. All right, you got a motion on the floor? To deny. Is there a second?
What?
The motion on the floor is to deny the waiver of the fee based on notice.
Okay, I know you got a motion on the floor. Can I speak?
Oh, sure, go ahead.
Can I speak even though you got a motion?
Definitely.
Okay. Well, given the fact that she did not receive proper notice on several occasions, and we cannot prove, and it cannot be proven that she did receive it, and then the ones that were signed actually was not her signature. I just think that due process, she deserves due process. And so I would have a problem with that because of those reasons.
No, and I tend to agree with respect to like actual notice versus constructive or substitute service from a due process perspective. But it's a good point. So we have a motion on the floor not to accept.
Go ahead, sorry.
No, because I do know that in some cases, some people, they decide that they're going to evade and not receive those notices. But in this case, there's no way of proving that she received it. So certainly, I just think that it would be unfair to punish her and not giving her the proper due process. And that's just my opinion.
Thank you.
My concern in response to that is that the commission's done everything it was told to do. We were told to send it to this address. We sent it to that address. After that, we have not failed or been derelict in anything that we were required to do under the law, correct?
Right, nobody, neither we nor the appellant is saying that.
So if we had received a return of service saying, could not deliver invalid address, then I can understand not receiving notice, but it was sent to where we were told to send it, and after that, we had no control over it actually landing on her desk from there. So, you talk about not evading or avoiding service. If she were concerned at all about the mail delivery system at the Miami-Dade School Board, she could have given us a different address. So using that now as a defense seems spurious.
I will add that the address is usually and almost always supplied by the coordinator for the agency. The coordinator certifies a list roughly every February or January where they supply us with the mailing address where, in this case, the supervisor of elections is supposed to send the notices. We pick it up afterwards, of course, when we send the postcard. But the address, at least initially, comes from the SOE.
Okay.
I'm sorry, from the coordinator.
All right. So my motion is to deny the appeal.
No, I understand. I'm trying to get a second. We got a second to deny?
All right, so the motion would fail.
Yep. Can I get a motion to approve, notwithstanding one of our commissioners' position? Can I get a motion to approve the final order as it's written?
Oh, it's written. Okay.
Yes. Is that a motion?
Oh, okay.
Thank you. Can I get a second?
Second.
All in favor, say aye. Aye. All opposed?
Nay.
Motion passes. Thank you. Go on to number 6. It's going to be the same.
Number 6 is Barry Miller. This is a very similar situation to the one that you just heard. Barry Miller is a former member of the Architectural Review Board for the Village of Ball Harbor. Commissioner Bain, he filed from 2018 to 2021, Form 1. Now, this pertains to his failure to timely file his 2020 Form 1. He did not timely file, so he accrued a $300 fine. He did timely appeal. And when it's an appeal, just like in the last matter, he's claiming he never received timely notice of his filing obligations. His specific argument is that all the notices were sent to his work office during COVID. Office staff was only working sporadically then, and no one must have been present to take the mailings. The issue here, why we're recommending waiving the fine based on this lack of notice argument, is again, we have nothing to contest the lack of notice argument. 3 notices were sent prior to the grace period expiring, all to the same office address. That would be an initial notice from the supervisor of elections, a certified notice from the supervisor of elections, and then a courtesy postcard from the commission. My notes here indicate regarding that certified notice, post office records indicate it was still in transit as of August 5th, that ultimately it may have been delivered, but the records don't indicate exactly when it was delivered. So we won't be able to tell whether it was delivered on or before September 1st, which would be very germane to his lack of notice argument. Again, because we don't have any evidence to dispute his claim of lack of notice, that's why we're recommending that the fine be waived here.
So this is one where it was actually sent to his office address where it had been received before. And there wasn't an argument that somehow it got lost in distribution.
That's correct. The argument, I believe, in his appeal is that it was during COVID, staff was just sporadically there, and the notices just were not passed along to him.
And he had filed previous forms, previous
sir.
disclosures.
I have a question.
Oh, go ahead. Sorry.
So, of the 3 notices sent, one of them had to have a signature that was given back to show that he had signed it in person, or someone had signed it in person, correct?
Correct. I don't believe, and I can check my notes here for this particular appeal, I don't know that we had in the file the actual signature. All we had was that it was in transit at the time, as of August 5th. That was the only record that the post office passed along to us. Let me just check that. and it said it was going to arrive late. This would be page 10 of the materials. The post office tracking indicates that August 5th, it was still in transit and arriving late. That was the only record we were able to get from the post office. So because of that, we don't know if he received it prior to the grace period, prior to September 1st.
So this is like the hypothetical I gave you earlier about the husband throwing away the notice sent to the wife. It arrived at his office. We know that he received other notices from his office. He's just saying he never got it. It wasn't that it was lost in mail distribution or anything. So, again, the standard of receipt is, the bar appears to be being set unreasonably high in application here. And I would for that, I'd recommend that we deny this appeal.
Mr. Shaver, real quick on this. I see here, is this going to have the same issues going to be going forward with the emails now? I think, Steve, you were mentioning something, or is that going to be a tighter way of ensuring receipt and delivery? Because it seems like with the system we have here, these are old cases. There seems to be a disconnect between our responsibility as the Commission on Ethics versus the standard of due process and notice, an actual notice. And it seems like, it appears that people may be avoiding the responsibility based on that, on that gap.
I mean, what's to stop someone from saying, I don't check that email address anymore?
Right.
What's to stop someone from saying, you know, my secretary checks that email address and I didn't know? So,
Go ahead, Steve.
The literal statute would prevent that. So the statute says that failure to check the mailbox will not be an acceptable, will not be considered to be an unusual circumstance, which is the standard for the appeal.
So how about I failed to pay my GoDaddy account, and my account was suspended for 3 months, and it must have fallen in there, and I never got noticed. And then they're back up 3 months later.
So if we encountered what I would interpret that to be as a technological thing, where the appeal is now not that they failed to, but they're essentially arguing impossibility, which is a defense in a lot of things.
Right.
We would, if that was something that they were arguing, we would present that to you, and then you'd get to vote on it.
Because I'm having a hard time reconciling that with a physical structure like a house, and you just can't pack, well, I guess you could theoretically, but for the most part, you just can't pack up an address and leave. But I understand the limitations, and also from a due process perspective, and the standard are there. But if you want, we can try that motion again. Have a motion not to accept
appeal.
the final order as recommended, to deny it.
That's
Can
my
I get a
motion.
second? Motion fails. Can I get a motion to approve the final order as written? Got a motion? Can I get a second?
Second.
Second, I have a second. All in favor, say aye. 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 All opposed?
Nay.
Thank you. And we move on to number 8, Juan Ruiz. You can proceed, Mr. Chairman.
Okay. Juan Ruiz is the former Assistant City Manager for the City of Lake Worth Beach. He's filed every year since 2017, although it's unclear if he was always in that position, if that was the particular position that triggered the filing requirement. This pertains to his failure to timely file his 2022 Form 1. He's accrued a $450 fine. He's timely appealed. This is a little bit different than the other situations. In the appeal, he's again claiming lack of notice because he's claiming the mail was sent to the City Hall for the City of Lake Worth Beach, but he left employment there in April of 2023 before any of the notices were sent. So he was no longer at that particular location. We have nothing to contest that lack of notice argument. Again, the 3 notices that were sent were an initial notice by the supervisor, a certified notice from the supervisor, which was returned as unclaimed and unable to be forwarded, and the courtesy postcard from the commission. But again, those all went to the same address at City Hall. Apparently, one of our staff members also emailed him on September 1st, the day the grace period expired, but that was sent to his city email address. And again, he was no longer employed at the city at that time. Based on all that, we're again recommending waiving the fine due to lack of notice.
Thank you. We try it again?
No.
That one is hard.
All right. Can I get a motion to approve 23002 in re Juan Ruiz as written? Second? Second, thank you. All in favor, say aye. Aye. All opposed?
Nay.
Thank you, motion passes.
Thank you.
Thank you, now let's move in.
Thank you very much.
Yeah. Get a motion now to approve as written, 1, 3, 4, 5, and 7.
Move to approve.
Second?
Second.
All in favor?
Aye.
All opposed? No opposition? Thank you very much. I can't believe I got those numbers right. And I understand your concerns, Commissioner. I get it. I understand it. It's, and with the emails, to me, it's also concerning.
Yeah, I think emails are going to be worse.
Yeah.
You're going to see all sorts of
That's gonna be a
technical
mess.
arguments people are going to make. I think we need to amend the rule to provide for constructive notice. In each of those circumstances, they knew or should have known. And for some reason, they're not required to apply that standard.
Okay.
I agree, I think you need to put that.
Yeah, that's something definitely, that would be more of a legislative,
We can amend the rule.
Yeah.
I don't think we have to get
Okay.
the legislature. I think it's a rule amendment.
We
do-
can research that.
If I may, you wouldn't even need to amend the rule. These are staff recommendations, and you are actually free to vote either way on them. The recommendation just reflects, we count votes as well as everybody else in the room. We make the recommendation that we think the board wants to see. If the board wants to see a different recommendation, we would present that. And, so it's really just, where is the board right now? If the board were to have denied these, then the recommendations going forward on ones that look like that would reflect where the board is.
Well, it seems to me when you take a public office, you have a public responsibility, and that they failed to meet that responsibility. And in each of those cases that I challenged, they knew or should have known, because they had previously filed financial disclosures. And the fact that they were derelict or failed to file financial disclosures for those specified years, to me, they're without excuse, because they knew or should have known from previous action, and they knew or should have known even more so from having taken the public office. So,
right,
but
so in other words, notwithstanding the notice, they know they had a responsibility.
that's what I fall back on. They knew that they had because they had previously filed
Correct.
notices,
Yeah, it goes to knowledge, right?
And they should-
Especially, right.
and they should have known just from taking the office to begin with.
Let's go ahead, Commissioner.
But didn't you say that not checking your emails will no longer be accepted and won't be an excuse, right?
Yeah, yes, Commissioner. Failure to check the email, failure to check the email inbox will no longer be considered to be, or is prohibited from being considered to be an unusual circumstance. There could be other unusual circumstances. I don't want to conceive of them necessarily out loud, but there are other things that would fit the bill, and we'll present those to you. Our chief recommendation here is, we explain what the reasoning is behind it, but the chief recommendation here is based on the fact that this is what the board has done in the past, and, one of the main tenets of administrative law is that similar cases are going to be decided similarly by the body. If they're going to make a change, it would need to be explained. We could do that, but to this point, the recommendation is, here's what we're proposing. It is consistent with what you've done in the past. And so we'd be able to do something different, and we could write that up and support that. It's just us, when we do these recommendations, we are making a recommendation and also anticipating what the will of the board is.
I mean, what's to stop me from speeding and telling the police officer my odometer was broken and I didn't know I was going that fast? I mean, it seems to me that there's a standard that we should hold anyone in public office to, and we're not holding them into that standard here of constructive notice, but here, to me, they were beyond constructive notice. They had specific notice because their previous actions showed that they had filed forms. So, I don't know what we need to do to affect a change to the rule, but or to the application, but it seems to me that it should be considered, and maybe the board can vote on deciding whether it wants to change course.
And on the heels of that, have we had cases similar to this? And maybe not be the main reason for the appeal, or maybe part of it. How has the court handled this in the past? Cases that have gone up on appeal, maybe with an issue similar to this with respect to notice, actual notice, or knowledge?
I've been a general counsel for this agency for about 3 years. We've not had to litigate one of these at the DCA since I've been general counsel. I don't have the institutional knowledge, well, even before I became general counsel, I've been back here now for almost 6 years, back at the agency. I don't think we've litigated one in the last 6 years, is my memory of it.
I've been here since 2013, and we've had many of these kind of arguments on lack of notice. Since 2013, we haven't had any appeals regarding them, probably because the fines have been waived and the parties didn't have any.
Okay. Yeah, if we can get something to the commission with respect to changing this, with respect to, I don't know how, is that it's going to be an internal rule change, or?
It would come through the recommendations that
I
you
got it.
see on the individual
On a
cases where
case-by-case.
you all would vote.
There wouldn't have to be any notice, like we're changing our posture or anything like that, so someone can't argue, like you said before in administrative hearings, prior decisions will govern future decisions, like, almost like a precedent. We're not bound by that?
We would need to.
I'm sorry,
if
without-
we were
sorry.
going to change course,
Without notice, I'd rather have,
yeah. If you were going to change course on this, we would need to explain what we're doing in the orders that we're writing. And it's just as simple as that. I don't mean to portray that we, as the staff attorneys, that we actually have an opinion on this. I think if you actually polled us, you might find that some of us agree with you.
right,
It's not, that's not what the issue is for us. It's not our opinions that matter because we don't get a vote. The opinions that we're anticipating on on these recommendations are the fact that we have a sense based on what the commission has done on these appeals this year, in years past, going all the way back. And so we're anticipating that, and also that reasoning has held up with this board.
It doesn't seem like we're held to the standard of service of a summons, and that's almost what we're doing here, is holding ourselves to the standard of service of a summons, where you're effective personal service on the person. But even the law allows you to serve summons by publication. So, but, we're doing everything that we're required to do, and that's still not enough, because we don't have proof that it was in their hand. And that to me is an onerous standard that anybody can evade by saying, well, I just didn't get it. I didn't get it because we were shut down because of COVID. I didn't get it because the mail clerk failed to drop it on my desk. And the mail clerk could have dropped it on their desk and they could have thrown it away. We just don't, but because of the standard we're holding ourselves to, because we can't prove the chain of custody, we're allowing these appeals to be approved. And then we have, why do we even have fines if there's no teeth?
The way that we have been interpreting as staff this line of reasoning is that the commission, at least the way that I've internalized it, is that the commission's goal here is not to get the fine to stick, but to achieve a filing, even if it's late, to get them to file. If they don't have notice, that's why we make so many phone calls even after the fact. When we go to investigate the willful, we try to get them to file the form even at that point. The commission's goal to this point has been to achieve a filing, and this has been part of that. The commission's approach on these, I feel, has probably been a part of that. If the commission's goal were to change, and it could easily, if we wanted to just take the legal argument to where you're saying, I think we could support that, and I don't think that would be problematic, but it would be a shift from what the commission has been.
It seems to me that it's not unreasonable to require anyone holding office to provide an address where we can send these notices. And if we send the notice to that address, whether it's the mail distribution clerk or your home, then we've done our job.
almost like a presumption that they were served.
Yeah.
Versus a presumption they would have to overcome.
And that seems to be the presumption. The presumption now seems to be, I didn't receive it.
Right.
Until you can prove I received it, I didn't receive it. That's the presumption. And it seems to me it should be the other way around.
Which would be okay if we didn't do so many steps or take so many efforts to contact them.
And my concern too, again, is the taxing of our resources to deal with these appeals. Why are we having to spend so much time for you to write these orders granting appeals when we've done everything we're supposed to do? And that's what I don't like about these appeals, is I think it's sending the wrong message. I think it's sending the message that you can just say you never received it and we're going to grant your appeal, because the presumption is you didn't receive it.
To the point that you're making, the floor for the law is where you're saying it is. know, the commission has taken an elevated approach to this point, but we could easily write it up, what you're proposing.
Yeah, I mean, if it's a rule that requires anyone holding office to provide an address, email, or physical address, then I'm fine with that, too. I wouldn't have a problem with them, just like you have to provide an address to the tax collector where you're going to pay your property taxes, whether it's the physical address where you live or another address. There's no reason why you couldn't have an address requirement here for providing these notices. And once we've done that, we wipe our hands clean.
Right.
We've done what we're required to do, and if you didn't receive it because the mail clerk didn't drop it off, then that's not our fault. So,
Another comment?
I'm still on the email.
that's what's going to happen.
Yeah.
That's exactly what's happening.
When you leave office and maybe you're getting things emailed to your office, that address no longer exists. So you could be sending it to a government email for an official to receive it, but they no longer hold office. So what do you do whenever these bounce back, when they bounce? It may not even be an elected official, it could be, someone that, is in a committee or something that's required. When they start bouncing back, do you have to just call them?
So there's a lot of things that the commission does when the emails do bounce. So first of all, and it's funny, the one commission meeting that we have Kim not come to, she's not here to explain it, but I'm sure she's watching and laughing. So I'm going to do my best imitation and try to explain what it is that we do. But maybe Carrie, maybe you know better than I with the bounced email. When we do get the bounced emails, we do attempt to reach out. One of the things that we did that I participated in is when we contracted with this new vendor for the call center, where we see that we have bounced emails and so forth, we are having that, if the person had an email that bounced and hasn't filed, we're placing outbound calls after July 1 to those individuals to effectuate the filing, again, to going above and beyond what we need to do, but it's in the public's interest that that filing do occur, and so we're taking steps to make sure that the filing does happen. You're going to see, for example, and I don't want to forecast too much, but I'm aware of an appeal that we have in-house right now where the email was a typo. There was a typo, the word Florida was spelled wrong in the email address. And so the person did not get the email that was supplied to us by the coordinator was wrong. So it's not that they didn't check the email, it's that it wasn't the right email box to begin with, right? So that's the type of thing where we talked about earlier where it's an impossibility. I would expect that a case like that is going to be recommending waiver in those circumstances. So you're going to see cases. I think we're going to feel our way through this as we go through appeals under the new system. They're going to look different, and the reasons are going to be different because the medium by which notice is being achieved is different.
Carrie?
So one of the significant things in the legislation that passed is it puts the requirement on the filer to keep an updated email address in the system. And so you'll see when you log in, one of the first questions you come to each year is this information good for you? So you have the opportunity to change it then. You can log in at any time to change it. Ideally, when people leave office, not only can they log in to change to a different email address, ideally their coordinator, who is an agency person, who provides updates to information when they're processed out as a part of their exiting process, whether it be leaving employment or leaving an elected or appointed position, they will then update that email address to a good email address. But these are some of the issues. You will see emails are a bear. And one of the things we have to do is we start getting these notices out. It's why we'll still continue to send postcard mailings, because maybe if they left and that email address didn't get updated, they'll see the postcard, they'll call us, and we can effectuate that. But it'll be a new ball game as we start to address appeals for forms that were filed with electronic filing. All of the old stuff will go away and it will be anew.
I think Commissioner Stewart's right, though, in that if we're having a hard time with physical addresses, how much harder is it going to be when we have electronic addresses? And how many more excuses are we going to be facing? I think we've got to do something, whether it's internal or external, to make it clear that the burden is on the person holding office to provide current and updated addresses and email addresses and information. And the presumption is that if we send it to the last address that you provided, that was the valid address. Otherwise, y'all are going to keep writing appeal orders, ad infinitum.
Thank you. I agree. All right, moving on. Item 7, spending authority. Carrie, the floor is yours.
Thank you, Mr. Chair, and thank you all for that discussion. Staff hears you, and we will govern ourselves accordingly as we work through the next ones. As to expenditures, you have in your materials a memo from me. I am looking toward fiscal year 25-26. My expenditure authority is limited to $10,000. There are a few things in the budget that you are already aware of that exceed that amount, and so I ask for your approval to make the expenditures related to the Westlaw contract for the year, which is at $15,191.52. Also, to pay our lease that we entered into a couple of years ago. This will be the third year of our lease, $101,916.50. That's paid monthly. The monthly amount is $8,493.04. We also have our contract with the Office of the Attorney General for our wonderful advocates and their staff. That amount is $473,640. And then also any litigation that is outside of our usual DOA hearings, et cetera, we effectuate that contract that we have with the Attorney General's office, which is separate from the advocates. We're currently, as you know, involved in litigation related to Form 6, and so I don't know what the invoices might be when they come in, but in the event that an invoice tops my expenditure authority, I'd like to be able to pay that. So with that, I ask for your favorable approval for these expenditures.
Go ahead.
Move it without discussion.
Can I get a second?
Second.
All in favor, say aye. Any opposition? Hearing none? It passes. Congratulations, Gary. Okay, item number 8. Commission voted to approve the 2025 meeting schedule last July. We would like the commission's approval for Carrie to work with the chair to make an adjustment to the commission's meeting schedule in 2025, if necessary, to accommodate some case-related scheduling challenges. Would anyone like to discuss the meeting schedule, or do I have a motion to allow the executive director to amend the 2025 meeting schedule in consultation with the chair to accommodate some case-related scheduling matters? The only reason is we can't discuss the substance of the case, but just if we can get a motion to allow Carrie and I to work together.
So move.
A second?
Second.
All in favor, say aye.
Aye.
Any opposition? We are, and that passes unanimously. Okay, item number 9. Oh, that's been postponed. I apologize.
It's been postponed.
Yes, it's been postponed.
Is there any opposition to it?
It's been postponed. Next is going to be item 10. Executive Director, your report, please.
Thank you. I have nothing to add to my executive director report, and it is my understanding from Steve that there is nothing further to add to the litigation report that is in the executive director report. Is there any kind of update you wish to make?
We're aware that we've not yet been served with a summons on something, but we're aware that maybe something is coming on a matter related to a case that's at DOA right now. So we're waiting to hear whether or not there's a case or not. So that'll probably, if it does exist, it'll show up in the next report.
All right.
With your approval, I'll move towards the legislative remarks and e-filing.
Definitely.
Okay, legislatively, members, I'm happy to tell you that the governor signed into law Senate Bill 348 that relates to the stolen valor and the civil penalty collection by the advocates, the ability to utilize withholding as a tool that becomes effective July 1st. So thank you to Senator Gates and the leadership of the House and Senate, and the governor for signing that. That is exciting. That was one of your recommendations as to the civil penalties. We had some other bills. Hot off the presses, House Bill 1049 was signed by the governor. That has to do with criminal penalties for knowingly and willingly threatening or harassing certain specified court personnel, and it includes Ethics Commission investigations in the official investigations in that particular bill. So aside from that, we are awaiting signature on the other items that are listed in that report that you have in your materials. We are following also, of course, public records bills that might affect the commission, so we can be certain to comply with those, as well as legislation that adds certain boards to the requirement to file financial disclosure. So that completes the legislative report, unless there are any questions.
Any questions?
I have a question. What happened to the appointees and their being able to be reappointed or a new commission for ethics? Where is that?
I currently don't have anything new to report in terms of appointments. We don't currently have any changes, but when we do, I'll be sure to advise. But I don't have anything to report on that at this time.
We just have 4 today, so we just made it.
We have 5. 5 is our quorum, yes. That does happen from time to time. It is summer as well, so.
So we don't have to be here in summer.
We do.
I'm wondering.
So people's schedules sometimes get complicated in the summer.
Yes, they do. Anything?
Okay. As for e-filing,
Yes.
disclosure season is underway, with the filing notifications of the requirement being emailed to more than 38,000 filers, including the folks seated here.
I didn't get mine.
I didn't get mine.
Well, consider yourself notified.
Stay quiet.
Anyone
say
watching,
something?
consider yourself notified. Due July 1st, no later than September 2nd, or you will get fined. Or you'll get a call from one of your wonderful staff members about it. Our call center is also officially operational. We provided them with about 40 hours of training on financial disclosure, and so we are underway. We also emailed reminder notices to filers on June 1st. For anyone who filed last year, you can just go on ahead and log in with those credentials and get going on your form. You'll recall it saves as you go. So far, the call center, as of about Wednesday of this week, I think, has handled 696 calls regarding the Form 1. Form 6 calls are handled by our legal staff in office. I don't have a count of those. Total incoming calls to the commission during the month of May was 3,336 calls, with the highest number of incoming calls being 508 on May 20th, when the email notices were sent out and received. Those email notices start generating overnight and go out in batches. We did expect a spike in calls when we sent the notices out on May 20th. However, we realized that morning that something seemed to be amiss with the system, and we were seeing for the first time a system overload that prompted an immediate response from our IT team at the Office of Legislative Information Technology Services, which is OLITS. They worked quickly to identify the issue and a course of action to quickly increase infrastructure resources. We placed the system into a maintenance mode for that work to be done, and after the time in maintenance mode was approximately 1.5 hours. Then we were back up again, and filers could access the system without error. This was the first time we encountered an unexpected system error that necessitated bringing the system down and into maintenance. As a long-term solution, OLIT's plans to scale resources proactively during peak filing season, and the OLIT's team is actively investigating as to the root cause, which has not yet been identified. But I want to emphasize that the issues were not the result of any sort of nefarious conduct. And it had been load tested numerous times, so we are continuing to look into that. As of yesterday afternoon, we were sitting at 42.16% compliance with the Form 1. That's 15,573 filers so far this year. And with the Form 6, we have 303 who have filed, which is 21.37%. This is a little bit slower of a pace than last year. We're not really surprised by that because this is not a qualifying year. Last year, we had a number of officials getting in early because they were qualifying to run for office. But what happens with the season is it builds and it builds and it builds. We maybe have a 2% a day increase in compliance. Then it starts hopping by 5%, 7%. It's something we keep an eye on daily. We do plan to have the call center place outgoing reminder calls to filers earlier than what we did last year. We'll also send, as I mentioned, those reminder postcards in August, as we have done in the past. For whatever reason, those postcards tend to get people's attention. And so that's been a great cost-effective tool for us. Those notices are not required by law, but they are something that we do in an effort to get the highest compliance possible. So with that concludes my e-filing report. I'm happy to answer any questions you might have.
You answered it. As far as the pace, it's a little bit slower, I guess, because of the lack of people that are,
That is our unscientific
No, honestly.
opinion,
but you're on the front line, so you would know.
But given the calls we were receiving last year, we ramped up earlier because it was the first year, it was an election year. We ramped up in April, and we were seeing more calls for Form 6 and Form 1 as people qualified.
Any questions for Carrie? Okay, I guess that concludes our public session. Can I get a motion to adjourn the public session?
So moved.
Second? All in favor?
Aye.
We are adjourned. Thank you.